Good evening. Welcome to the New York City Bar Association. This event is co-sponsored by the National Moot Court Competition Committee of the New York City Bar and the American College of Trial Lawyers. My name is Daniel Rothschild. I'm co-chair of the National Moot Court Competition Committee here at the New York City Bar, and I'm joined by committee member Zach Withers. The argument that you are about to see is the culmination of an intense competition that spans 5 months. In November of this past year, 159 teams from 117 schools participated in 14 regional competitions across the country. Each region sent its 2 best teams to compete this week in the national final rounds here at the New York City Bar Association. We began the national rounds with 28 teams, but after 4 days and 42 arguments, we're down to these 2. We're going to now give you a brief factual summary, and then we'll move on to additional preliminary information.
Fact pattern of today's case starts in 2018. In this fact pattern, in response to a series of large protests organized by undocumented immigrants in the United States seeking changes to immigration law, the federal government passed the Alien Sedition Act. The act states that it shall be an aggravated felony for any person who's present within the boundaries of the United States without legal authorization to organize or participate in any public demonstration within the United States intended to advocate for a change to any law of the United States or to advocate for or against the election of any person to be an officer or representative of the United States. The government's stated rationale for the act was that the participation of undocumented persons in rallies and protests within the United States threatened to intimidate American citizens and overwhelm their legitimate right to be heard. The government also stated that in their opinion, the speech of undocumented persons on political topics is not protected under the First Amendment. The petitioner in this case, Mr. Cal L., is a 41-year-old undocumented alien who has been in the United States since 2009. He entered the United States from his home country, the Republic of Kryptonia, on a tourist visa and never left. Prior to the events in this matter, Mr. L. had no criminal record and has been consistently employed as a writer for Kryptonian language newspaper in the state of Metropolis. Mr. L., during the time he was in the United States, married a United States permanent resident, had a son, but divorced before obtaining legal residency himself. In 2019, Mr. L. participated in a major demonstration in support of an act then pending in Congress which would have granted a path to legal residency for Kryptonians present in the United States. During the protest, Mr. L. made an impromptu speech to the crowd in which he identified himself as an undocumented immigrant and exhorted all present to call their congresspeople and ask them to pass the act. He was promptly arrested by FBI agents present at the scene and charged and convicted of alien sedition under the Alien Sedition Act. He was sent to prison, and upon his return from prison, received a notice of intent to issue a final administrative removal order from the Department of Homeland Security. The order indicated DHS's intent to remove him from the United States back to Kryptonia under a statute providing for the expedited removal of aliens who have committed aggravated felonies. With the notice, Mr. L. received a form with 4 checkboxes giving him grounds on which he could contest his removal. Those grounds being that he is a United States citizen, that he is a United States permanent resident, that he never committed an aggravated felony, or that he wished to attach documents supporting his case. He checked the box regarding documents and submitted a letter stating that he wanted to have a hearing before an immigration officer. At that hearing, he pleaded with the officer not to deport him, arguing that he feared returning to Kryptonia and that he made him a life for himself in the United States. His plea was rejected, and DHS issued a final order of removal. Following the issuance of the order, Mr. L. appealed that order to the 14th Circuit Court of Appeals in accordance with applicable law. Mr. L. stated in this appeal that his conviction under the Alien Sedition Act violated his First Amendment rights. Were he not convicted under that act, he would not be an aggravated felon, and if he was not an aggravated felon, he therefore would not be deportable in an expedited manner. The 14th Circuit dismissed his petition initially, stating that he had failed to exhaust all of his administrative remedies with ICE, but en banc, they reversed themselves, held that he did have a right to be in court, but that he lost on the First Amendment issue and his rights had not been violated. Following that ruling, a petition for certiorari was sent to the Supreme Court from both parties, leading to today's action.
We'll see argument in a few minutes, but first we wish to introduce the teams and then our judges. For the teams, representing petitioner Kal El is St. Louis University, counsel of which are Ashton Dietrich, Mesa Daoud, Aaron Freeman, and coaches Paige Confield. Representing the respondent, Joseph Luther, in his official capacity as Attorney General, the University of Georgia, John Sternberg, Jonathan Kaufman, John Lex Kennerly, and Kelly Casey. We're honored to present the judges who will preside over the final round of the 70th National Moot Court Competition. The Honorable Edgardo Ramos, a United States District Judge for the Southern District of New York. The Honorable Ono Wang, United States Magistrate Judge, Southern District of New York. Justice Judith Gish, Associate Justice, New York Supreme Court, Appellate Division, First Department. Roger Maldonado, the President of the New York City Bar Association. And Douglas Young, President of the American College of Trial Lawyers. The final round of the 70th National Moot Court Competition will begin shortly.
All rise. The Honorable, the Chief Justice and Associate Justice of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
You have to tell us where we are.
Right. Oh, we'll take care of that.
Young?
Yes, you got that. Very good. All right, you may all be seated. Young? Good evening and welcome to the Supreme Court of the United States and to the 70th Annual National Moot Court Competition Finals. We are about to hear the argument in the matter of L versus Luther. Counsel? Would you introduce yourselves and request time?
Yes, Your Honor. Ashton Dietrich for the petitioner, and I'll be requesting 2 minutes for rebuttal.
You may have it.
Madam Chief Justice, and may it please the Court, my name is Ashton Dietrich, and I, along with my co-counsel, Mesa Daoud, represent the petitioner, Kal El. I'll be addressing the first issue on jurisdiction, and Ms. Daoud will be addressing the constitutional issue. And we respectfully request 2 minutes for rebuttal. Congress did not intend for empty procedure to bar the federal courts from hearing constitutional claims. And for 2 reasons, the 14th Circuit properly heard Mr. L's claim. First, even if Mr. L would have raised his constitutional argument DHS lacked the authority to address it. And second, Mr. L had nothing to exhaust because the expedited removal process only holds out factual challenges, not legal challenges. Today, Mr. L challenges the constitutionality of the Alien Sedition Act as a whole. This court found in McCart versus the United States in 1969 and then reaffirmed in Matthews versus Diaz that administrative officers do not have the authority to invalidate statutes or even to entertain facially constitutional challenges to the validity of a law.
Is there any remedy under the statute if a hearing officer is confronted with a legal issue during the proceeding?
Your Honor, the remedy would be that the hearing officer would be able to send the case to an immigration judge, but that relief is still insufficient because even the immigration judge is also not qualified to address the constitutional claim. Moreover, the regulation governing that relief, 8 CFR section 238.1 D23, is entirely subjective in nature because it allows the hearing officer discretion to actually transfer that claim. The language of that regulation says that if the hearing officer finds that the alien is not amenable to the removal proceeding, then the hearing officer shall send the case to the immigration judge. However, because it's discretionary and because it's subjective, it's not sufficient.
Right, but I mean, if Mr. L had stood up at that point right before when he was asked, do you have anything else to raise? And he says, affirmatively says, no, I have a constitutional issue here. I mean, how discretionary is that in reality with the hearing officer? And then, I mean, for him to just even say the words First Amendment challenge, right? Or I can't be convicted, or this law doesn't apply to me. I mean, he's pretty articulate as I can understand it. So why, I mean, it's a very low bar. Why couldn't he have said that?
Your Honor, while he could have said that, the hearing officer still lacked the authority to address it, and it raises substantial Marbury issues if that hearing officer actually would have adjudicated on that claim of whether the Alien Sedition Act is constitutional.
Wait, didn't you just say that the hearing officer can then send it to the immigration judge? I mean, what we're talking about here is notice, right? That the lower courts or the lower bodies have a chance to address it before it comes before us.
Your Honor, those lower individuals cannot address the claim because even the immigration judge lacks the authority to adjudicate the constitutional claim, which is what this court found in McCart and what this court found in Matthews versus Diaz. Moreover, this court noted in Woodford v. No in 2006 that an alien can only exhaust those remedies that the agency holds out as a right. And as the 4th, 5th, and 9th circuits have held, the expedited removal proceeding only holds out issues of fact, not issues of law.
Would the hearing officer have had the ability to stay the proceeding entirely so it could have been adjudicated by a proper court?
Your Honor, while the hearing officer could have stayed the proceeding, there is no automatic appeal to the Court of Appeals that the hearing officer could have sent it up to. Moreover, that undermines the purpose of the expedited removal process, which is to expedite removal hearings. Now, the 4th Circuit pointed to the regulation governing those expedited removal proceedings, and it reasoned that Section 231 directs the hearing officer to issue a final order of removal only if there is no genuine dispute of material fact. The regulation using the summary judgment language demonstrates that this is in fact a fact-finding process, not a legal one. Moreover, Section 238.1 instructs that the alien can produce only certain evidence in the expedited removal proceeding, such as affidavits, documentary information, or other specific evidence. The regulation doesn't include legal briefs or memoranda, and all of this demonstrates that it's a factual proceeding.
But the language of the form itself does not seem to be so limited. The language of the form itself, and indeed the conversation that was had during the hearing itself, indicated that the hearing officer apparently was open to hearing any argument, any additional comment that Mr. Earl may have wanted to make, no?
No, Your Honor, because the notice of intent indicated in the record on page 7 is limited to factual arguments only, and that is precisely what the 4th, 5th, and 9th circuits have all found. the check boxes on the form are all related to factual contentions, namely whether the individual was in fact the individual who created or who committed the crime. And while that fourth checkbox does allow the alien to attach any other documentation in support, the regulation instructs that the alien can only attach factual arguments, and moreover, the hearing officer would not be able to adjudicate any sort of constitutional
So
claim
there's
that he
no,
brought.
under no circumstance may the petitioner or someone in his position raise a legal argument at this hearing?
At this hearing, no, Your Honor, because the purpose of that hearing is to adjudicate only factual arguments. The Fifth Circuit in...
Can I ask you a question? I'm looking at the form itself, and the form allows for Mr. L., and he did take advantage of it, to attach documents. He didn't expressly attach documents that were factual in nature. In fact, what he did is he requested a hearing, correct?
That's correct, Your Honor.
But he didn't request a hearing on any factual issue. He didn't actually identify what he wanted a hearing on, just that he wanted to contest this, correct?
Yes, Your Honor.
And so here's the question. He did get a hearing. At the hearing, he was asked by the hearing officer if he had any other arguments to raise, and he didn't raise them. Could he have, at the hearing, that's not specifically indicated in the notice of intent, could he have at that time raised legal issues?
Your Honor, while he could have raised legal issues, that hearing officer was not qualified to address the legal issues, and the expedited removal process is tailored only toward factual arguments. The Fifth Circuit noted in Valdivez-Hernandez that hearing officers need not be lawyers, they need not be judges, they need not have any legal training or experience at all, and that is why they are specifically qualified to hear factual challenges but not legal ones.
So it is your position, I mean, the hearing officer denied his appeal, that under no circumstances may someone in his position present a legal argument. They can't do it in the form, they can't do it by attachments, and they can't do it in any event, because even if they tried, the hearing officer would not be able to adjudicate that.
Your Honor, it's not that they can't raise the legal arguments. They can. It's just that Congress, the statute, does not require the aliens to raise those legal arguments in order to exhaust all issues, because the expedited removal process is tailored only toward factual challenge. This is precisely what Congress intended in Section 1252 in House Report 10972, which was published in 2005, the same year that Congress passed the Real ID Act. Congress explained that in removal proceedings, no alien, not even criminal aliens, will be deprived of judicial review of constitutional claims. Congress explained that the Real ID Act gives every alien 1 day in the Court of Appeals, satisfying constitutional concerns. Congress included this information in the House report specifically to address the constitutional issues that arise out of these expedited administrative removal proceedings.
So is it your position that it's the nature of the argument that Mr. L is making, being constitutional, that it holds a special status than any other legal argument that he might make in terms of the exhaustion of remedies, or are you advocating for a blanket rule for any legal argument?
The former, Your Honor. While all constitutional arguments are legal arguments, not every legal argument is a constitutional argument. There is a difference. And even the BIA agrees that it lacks jurisdiction over constitutional concerns, such as invalidating the validity of a statute.
What would have happened in this case if Mr. L had said, oh yeah, and another thing, the law that I was convicted under is unconstitutional?
Your Honor, he could have said that, but he was not required to exhaust it because Congress explicitly intended that he be allowed to raise that constitutional argument directly to the Court of Appeals, directly to the body that has the authority to adjudicate that claim. In INS v. Chadha, this court noted that both the immigration judge and the Board of Immigration Appeals agreed that they had no power to declare unconstitutional an act of Congress. The BIA's own administrative opinions repeatedly repeat the phrase, "We have no power to declare unconstitutional the statutes that we administer." And because the BIA and the IJ and the hearing officer have no power to adjudicate these types of constitutional arguments, that demonstrates that Mr. L raising those arguments would be futile. And futility does not require exhaustion. That's what this court found in McCarthy and in Matthews.
But adjudicating is one thing, and just sort of issue spotting is another. And if he had raised the legal argument before the hearing officer, wouldn't he or she have been duty-bound to pass along that argument?
According to the regulation, yes, but that regulation is still discretionary in nature because it gives that hearing officer discretion to decide whether that hearing officer thinks that he or she is qualified to hear that type of claim.
But I think it's a slightly different question. If the issue is raised, I think the question is, does the hearing officer have discretion, or must he or she push that legal issue to another court that does have the power to adjudicate it? It sounds like you're arguing for kind of a bifurcated procedure here, which is not the best use of judicial resources.
Yes, Your Honor, that hearing officer does not have the discretion to send the case to the Court of Appeals. If the hearing officer feels that that hearing officer is not able to address the claim, then the hearing officer would be able to send the case to an immigration judge who equally cannot decide the claim.
What do you mean cannot decide the claim? It's one thing that an immigration judge can't declare a law unconstitutional, but are you saying that they also cannot determine whether or not the person was properly convicted, for example?
Your Honor, it's undisputed that Mr. L was properly convicted here, but the specific legal argument that Mr. L raised to the hearing officer is not one that the hearing officer would have been able to address, which is precisely what this court found in McCart and in Matthews when it found that administrative officers don't have the authority to hear these types of claims.
Can you reconcile the position that you're advocating here with the Seventh Circuit case of Fonseca Sanchez, where it concerned a U visa, and even though ICE didn't have the authority to decide on the U visa application, the court found no jurisdiction, that the petitioner there was at least obligated to raise the issue and seek a stay of the deportation proceedings?
Yes, Your Honor. Petitioner does acknowledge the circuit split in that the Seventh Circuit, along with the Eighth Circuit, have found that in those expedited removal proceedings, aliens can raise both factual and legal arguments. However, there is a difference between legal and constitutional arguments, and matters of first impression, matters of invalidating congressional statutes are not the sort of claims that administrative officers can adjudicate. In INS v. St. Cyr, this court found that it would give rise to substantial constitutional questions if construction of a statute would preclude a pure question of law. And as Chief Justice Marshall penned in Marbury v. Madison in 1803, it is the province and duty of the Judicial Department to say what the law is. Today, Mr. L seeks to defend that province, and that's why we respectfully request this court affirm the 14th Circuit. Thank you.
Thank you. You may proceed.
Madam Chief Justice, Your Honors, and may it please the Court, my name is Mesa Dawood, and I am arguing Issue 2 of this appeal on behalf of Mr. L. The petitioner requests this Court reverse the 14th Circuit's decision to deport Mr. L because the government is trying to silence the voice of an already marginalized individual who is entitled to protection. This Court should reverse the 14th Circuit for two reasons. First, Mr. L is entitled to First Amendment protections given his sufficient connection to the United States. And second, the Alien and Sedition Act in its entirety is unconstitutional because it is not narrowly tailored, nor does it serve a compelling government interest. Turning to the first point, Your Honors, Mr. L is entitled to First Amendment protection given his sufficient connection to the United States.
How do we determine sufficiency under the standard you're pushing? What facts exactly are you looking to?
Your Honor, there has been a line of cases by the Ninth and the Seventh and the Fifth Circuits that have all looked to sufficient connection. There, the courts have addressed whether an individual has accepted societal obligations. In the Seventh Circuit's case in Meza Rodriguez, the Seventh Circuit took up a set of facts that are almost identical to this case. There, the individual was in the United States for 20 years. He had worked on and off here. He had close family ties and ties to the community, and the individual also attended public schools here. Unlike Mr. L., that individual had a pretty extensive criminal record. There, the court found that the individual had a sufficient connection to the United States given those factors. Furthermore,
I'm sorry, counsel, but does it make a difference in making this analysis whether the underlying right that you are seeking to assert is one that is protective versus affirmative? And if it makes a difference, isn't speaking an affirmative act rather than something that is protected?
Your Honor, it absolutely does make a difference. Here, the First Amendment is a protective right. This court in Kwang Kai-chu v. Colding in 1953 held that when it comes to the First Amendment, citizens and aliens are not treated differently because the First Amendment is an inalienable privilege that extends to all persons to guard them against government encroachment. There is not one majority opinion that has been published by this court that has found that the First Amendment is not a protective amendment.
But circumstances change, and our elected representatives saw fit in their consideration that the fact that many of our communities were being put upon by speech by undocumented individuals that were disrupting those communities. And so why shouldn't we look to the considered judgment of our elected representatives in determining, we should step in and do something now?
Your Honor, that goes entirely to the constitutionality of the act as a whole. In order to actually serve a compelling government interest, the United States would have to show that there is, according to this court in Turner Broadcast v. FCC in 1994, that the anticipated harms that the government is relying on as a means to justify the act, here being the Alien and Sedition Act, are actually real harms. They're not merely conjecture, and that the regulation would in fact alleviate those harms. Here on the face of the statute, the government has identified exactly what Your Honor has identified, that by Mr. L engaging in this type of activity, an individual such as an American citizen might feel that they couldn't speak out. However, that would be a conjectural harm that the government's identifying. There's no evidence on the record that that's a concern that the government has dealt with in the past and that they're now seeking to address. In United States v. Virginia, this court in 1996 held that in arguing that a law serves a compelling government interest, the government's justification must not be hypothesized. It must be a genuine issue and not invented post hoc in anticipation of litigation.
Well, what about this as a genuine issue? Foreign government sends one of its citizens to the United States, and that person is here on an illegal basis, and that person's specific role is to disseminate disinformation to voters in the United States to get them to vote in ways that will assist the foreign government and hurt the United States. Isn't that a legitimate interest for the government to be seeking to protect against?
Absolutely, Your Honor. That would be a foreign interference in our election. However, my response to that is twofold. First, that individual would not be entitled to First Amendment protection for that speech because certainly they wouldn't be a citizen, and they also wouldn't have the sufficient connection that Mr. L has. Second, if that's the concern that the government is citing today, that would have been a concern invented post hoc in anticipation of litigation. Looking to the statute and looking to the record as a whole, the government has not identified that as a concern. And furthermore, Your Honors, the type of speech that you identified is something that this court has already taken up in cases such as Citizens United and a case that the D.C. Circuit decided in 2012, that being the Blumen case. Those cases both dealt with foreign interference in our elections. There, the court drew a distinction between express advocacy and issue advocacy. this court defined express advocacy as monetarily contributing to a campaign. The Blumen Court, which this court summarily affirmed, left open the question of whether soft speech or issue advocacy was actually something that could interfere with our elections. Furthermore, that goes to...
It didn't decide that case, nor did the Supreme Court, nor did we in Citizens United. In fact, the majority opinion expressly said we're not going to discuss this issue. So my question to you, does it make a difference, or should there be a difference between people in the Blount Garden where they were lawfully in the United States, albeit temporarily, and Mr. L, who is not in this country lawfully?
Yes, Your Honor, there would be a difference because Mr. L has sufficient connections to the United States. This court in Verdugo Urquidez in 19...
So the issue is I don't mean to interrupt you, but I just want to bring this thought forward. So the issue of sufficient connections, that is the key in terms of what you're arguing to us, and not whether the person is here legally or not legally.
Absolutely, Your Honor.
The person legally or not legally should be treated the same for First Amendment purposes as long as they had the substantial connection. Is that your position?
That is our position, Your Honor. The question does not turn on whether the individual has legal status here. That's not what this court held out in Verdugo Urquidez in 1990. Rather, the court there held that all people of the United States who would be entitled to the First Amendment protections are those who certainly would be citizens, lawful permanent residents, and those with a sufficient connection.
So I want to just bring this forward in the context of the litigation that's been going on concerning the Second Amendment.
Yes, Your
All
Honor.
right, and there the cases are split as well, whether an illegal alien has the right to Second Amendment rights. And one of the things, or at least one line of authority, says that because under Heller we talk about the Second Amendment belonging to law-abiding people, that it's okay to draft a law that doesn't provide Second Amendment rights to illegal aliens because by their very nature of being here illegally, they're not law-abiding. Why doesn't that reasoning apply to the First Amendment as well?
Your Honor, that reasoning doesn't apply to the First Amendment because the Second Amendment is an affirmative protection. The respondent has relied on that this court's opinion in Heller. This court did decide that individuals who are law-abiding citizens would be entitled to Second Amendment protections. Our position today is not that Mr. L would be entitled to Second Amendment protections because the Second Amendment is an affirmative right. Rather, Mr. L and all individuals like Mr. L with a sufficient connection are entitled to protective amendments.
But why should we determine that he has sufficient connections? He's been here 10 years. He's divorced. He's a bright fellow, apparently. He writes for a newspaper, but he's never made any effort to normalize his status in the United States. He's been living not in the shadows, but certainly not within the realm of the laws of the United States. So why should we grant him the status that is privileged?
Your Honor, we should grant him a status that is privileged because his contributions to our community, his family ties, whether he's divorced or not, do indicate that Mr. L has a sufficient connection. Page 3 of the record indicates he's an active member of his community. He has started his very own charitable organizations, some even including fixing sidewalks. He does provide child support to his child, who's an American citizen, and he continues to support that child. Page 3 of the record also indicates that Mr. L did begin the process to change his status. That would indicate that Mr. L not only has an interest, but has taken active steps in further investing himself in the national community.
I want to take this back to the language of the statute, which says, which is for any person who is present within the boundaries of the United States without legal authorization. So, by my colleague Justice Maldonado's hypothetical, someone sent here on a tourist visa from a foreign country specifically for the purpose of interfering with an election or with the passage of a statute does not fall under this law, Whereas, and if Mr. Kal-El had spoken up about the statute when he was here in a documented status, he would have been fine. But suddenly, like the day after his visa runs out, he is then he's covered by the law.
Exactly, Your Honor. That's how this law would operate in the way that the government seeks to enforce it. And so that leaves out individuals like Mr. L who have substantially contributed to their community and the national community at large. Furthermore, the statute is problematic because it's not narrowly tailored. Your Honor points out that individuals such as Mr. L, who maybe the day after their visa expires, could be picked up and charged under the statute.
Well, but it is narrowly tailored because it specifically defines who falls under the law and who does not, right? And you know, your argument about substantial connections, I mean, it kind of turns itself on its head because you're saying that somebody who doesn't particularly have a connection to this country would still not be prosecuted under this law so long as they had, you know, were here with proper authorization.
Well, Your Honor, in your example, certainly the individual who is sent here for the purpose of interacting with individuals to interfere in the election process would be subject to the considerations this court took up in Citizens United or even under the Blumen standard. Those cases go to express advocacy. So if that individual came to the United States and began saying, vote for this person, don't vote for that person, that would be considered express advocacy because it directly could result in a change in the election process. Mr. L wasn't even advocating for a specific individual for his community members to vote for. He was educating them on an issue that his community faces and just urged them to educate themselves further and to go out and vote. And
Well, he was advocating for a particular law to be passed.
Yes, Your Honor.
All right, so let's say an individual who was living in this country, who had come in legally, stayed beyond the time that their tourist visa allowed them to stay on, had a connection to the community, advocated in public forums for an overthrow of the government. Suppose they were an anarchist. The government wouldn't have an interest in protecting against that kind of speech?
Your Honor, if that individual has a sufficient connection, this court, in its Verdugo-Urquidez opinion, held that that individual would be entitled to First Amendment protections. Certainly, that individual would be subject to other First Amendment restrictions like all citizens are. But by virtue of establishing the sufficient connection, they fall under the people. For these reasons, we ask this court to reverse.
Thank you. Respondent? You may proceed, Counselor.
Thank you, Madam Chief Justice, and may it please the Court. My name is Joe Sternberg, and along with my co-counsel John Lex Kennerly, represent Respondent, the United States Attorney General. In a few minutes, Mr. Kennerly will show why enforcing the Alien Sedition Act against petitioner did not violate the First Amendment. First, I will show why the 14th Circuit never should have considered that issue in the first place. There are two main reasons, and for each, this Court should reverse on the first issue. First, petitioner was required to exhaust all administrative remedies made available to him as of right. And second, despite multiple opportunities to do so, petitioner failed to contest the sole legal basis for his placement in expedited removal proceedings.
Let me just ask you something right there. He's not a lawyer, is he?
He's not,
And so
as far as we know.
how would he know that he had a legal issue that he could present?
It is his burden to know what the law is and to know whether or not he has to raise a legal challenge. And petitioner was put on notice, beginning with the notice of intent, that he had the opportunity to raise both factual and legal challenges. So if I may go to page 7 of the record. Wait, shut.
How does that form give him notice that he's supposed to raise legal challenges?
So about a third of the way down this form, in bold and underlined text, is the word charge. And it says, you are deportable, ... because you have been convicted of an aggravated felony. So he is being put on notice that the reason he has been placed in expedited removal proceedings is because of his alien sedition conviction. And that makes sense because there are three prerequisites for the Department of Homeland Security to utilize expedited removal. The person is not a citizen, they're residing here unlawfully, and they've been convicted of what Congress has said is an aggravated felony.
Well, he knows why he's there, but you go down a little bit further and it says, I contest my deportability because.
Right.
And none of those boxes speak to the charge.
Well, I disagree. The last one does. That last one reads, I'm attaching documents in support of my rebuttal and request further review. Rebuttal to the charge that you were deportable because
Right,
you've been convicted.
So then you go to page 8, and for someone who's not a lawyer, he says, please give me a hearing so that I may explain why I should stay in the United States.
Right. And he was.
I mean, he's not a lawyer. How much more do you want him to say? I mean, he's explicitly asking for a hearing.
And he was granted one. And I will note the Department of Homeland Security was not required to grant him a hearing. This was an insufficient reply, this one-page letter that appears on page 8 of the record, that regulations require that in writing, if an alien chooses to rebut the allegations, the alien's written response must indicate which findings are being challenged and should be accompanied by affidavits, documentary information, or basically anything else. So this is...
Right, but when you say which findings should be challenged and then affidavits and documentary evidence, I mean, isn't that just only going to facts? So it's, again, suggesting that the hearing is only to address issues of fact, not issues of law.
No, Your Honor. It goes to both factual and legal issues. And I do believe it was Your Honor that said it's a very low bar for petitioner, or would have been a very low bar for the petitioner to put the Department of Homeland Security on notice that he had a legal challenge to raise. All he would have had to say is, I have a legal challenge. I have a constitutional
And then
challenge.
what would have happened after that?
Under the regulatory framework, and this is cited by petitioner, the exact same regulation. This is 8 CFR 238.1 D23. And I'll just read it, if I may. If the deciding officer finds that the alien is not amenable, and I'm paraphrasing a little bit, not amenable to expedited removal, the deciding officer shall terminate expedited removal. The deciding officer is required, per the regulatory framework, to terminate expedited removal proceedings, and that is meaningful relief for Mr. L. He concedes that he has no legal right to be in the United States. So if he is removed from expedited removal, then he has the opportunity to apply for certain forms of discretionary relief, temporary protected status.
Do you read the word amenable to mean legal status or factual? How are you reading it out of that statute?
Yes, both, factual and legal. And that's what the 11th Circuit said in Malu versus United States Attorney General. All Mr. L would have had to do is say, I have a legal challenge, I wish to raise this, and then the Department of Homeland Security officer, in this case ICE Officer Sullivan, would have been required to terminate expedited removal proceedings.
Wouldn't you agree, though, that it's hard for a non-lawyer, no matter how educated, presented with a form like this, which doesn't have the word legal in it anywhere I can see, and given 10 days to develop his claim and present it, that's a hefty bar for a lawyer. Why isn't it fatal to your argument here?
I agree, Your Honor. This form is not perfect. We concede it's ambiguous. Could it be a lot better? Yes, absolutely. If I were the Secretary of Homeland Security, the form would probably look a lot different. But that's not the test. If this case is about whether this form is perfect, then we're going to lose. The fact is...
Well, aren't there cases that have opined on the clarity of forms such as this?
There are.
And didn't those cases suggest that it appears that the form only requests factual and not legal defenses to deportation?
That's right.
And thereafter, it appears that the department did nothing to clarify the forms, correct?
Correct.
And so why shouldn't we conclude, therefore, that it was a conscious decision made to ensure that individuals with legitimate legal arguments were made or were kept in the dark about those arguments so that they could be deported expeditiously?
Well, those cases, such as Etienne versus Lynch, Valdivia Hernandez versus Holder, even Malu versus United States Attorney General, none of those cases involved a hearing, and that's what we have. That's what makes this case different.
Well, you said earlier that you're not even required to provide a hearing, correct?
That's right.
So Mr. Al L. could have been convicted, served some time in jail, taken directly from his jail cell and deported? Is that what you're saying could have happened here?
Not well. That essentially that is what happened because he didn't say anything about his legal challenge.
No, but he had a hearing,
Right.
such as it was. But you're saying that he wasn't even entitled to what he received. Is that correct?
Correct, but the test here, and this is what this court has said in Woodford versus No, exhaustion of administrative remedies means using all steps that the agency holds out and doing so properly. So here, not only did the Department of Homeland Security hold out this notice of intent form, it also had this hearing transcript that appears on page 9 of the record. And at that hearing, ICE Officer Sullivan specifically asked him, or she said, if I'll just read it, she says, "Nothing you said is sufficient to raise a legal challenge to the reason for your removal. You were convicted of an aggravated felony and do not have legal status to be in this country. Have we covered all of your arguments?" And he replies, yes. So have we covered all of your arguments? If that's not holding out the opportunity to raise a legal challenge, then I don't know what is. So here the Department of Homeland Security provided not one, but two distinct opportunities for Mr. L to raise a legal challenge. And had he simply said something, then the Department of Homeland Security could have granted a stay, could have declined to issue.
What was the second one was the hearing officer saying, do you have anything more to say? What was the first one?
The notice of intent form, in which he was provided the opportunity to provide any sort of documents, any sort of evidence whatsoever, even just a letter that says, I have a constitutional challenge, I wish to appear in front of an Article III court.
And this is the very form that you concede is ambiguous.
That's right. So, but even if you disagree with me on the form, that the form constitutes an opportunity to raise a legal challenge, we still have this hearing on page 9 of the record. And had petitioner, the question's been put out there, what would have happened? Well, in Fonseca Sanchez versus Gonzalez, which is petitioner addressed, Ms. Fonseca Sanchez, she desired a U visa relief given to victims of domestic violence. And her argument was, well, ICE can't give me a U visa, USCIS can, therefore it makes no sense for me to ask ICE for a U visa. The Seventh Circuit said, well, that really doesn't matter. What the Seventh Circuit said ICE could have done is issue a stay, declined to issue a final administrative removal order. And that's what could have happened here if Mr. L had simply said something. Hey, I wish to raise a constitutional challenge. ICE Officer Sullivan would have been required by law to terminate expedited removal proceedings and then could have, we concede that it is discretionary whether to convert expedited removal proceedings into regular removal proceedings, in which case petitioner could have appeared before an immigration judge. And we also agree with petitioner. There's nothing an IJ can do about the constitutionality of a federal statute.
Could he have brought a lawyer to this hearing?
He certainly would have had the opportunity, yes.
Is there anything in the form that tells him that?
He would have been, per the regulatory, no, there's not in the form, but per the regulatory framework, he would have been provided the opportunity and also a list of legal services. And I will just note, the record is silent on whether Mr. L had counsel, but the only mention of counsel in this record is that Mr. L has waived any ineffective assistance claim. So I don't see why you would need to waive an ineffective assistance claim if you did not and have.
Well, doesn't that ineffective assistance claim that's waived go back to the criminal case? I thought, I believe in the record that he appeared before the hearing officer pro se by himself. Is that not an accurate reading of the record?
Well, I believe you're referring to the appearances at the top of page 9. Certainly there's no mention of counsel, but petitioner is not challenging raising any sort of ineffective assistance of counsel claim. So the short answer is the record is unclear, but he certainly would have had the opportunity. And I do want to address something petitioner raised, and that's sort of this concept of drawing a line between constitutional and non-constitutional claims and why there's a problem with that. First is, that's not the question this court granted cert on. This court granted cert on whether to require the raising of legal challenges or factual challenges. And here's the other problem with drawing a constitutional, non-constitutional line. There are some expedited removal cases that the Department of Homeland Security is able to deal with, and that's sort of what I refer to as the classic expedited removal case. And the classic expedited removal case involves a state-level criminal offense, say simple battery. That's what it was in Malu versus United States Attorney General. The claim by the undocumented alien is not that this statute under which I was convicted is unconstitutional. It's simply that this statute does not constitute an aggravated felony for the purposes of the Immigration and Nationality Act. Those claims the Department of Homeland Security is well equipped to deal with. So in those cases, if the issue is raised, the ICE officer or whoever it may be can transfer that case to an immigration judge who does have the ability to deploy the categorical approach and determine whether that state-level criminal offense constitutes an aggravated felony.
But
And
that's not the case here, correct?
That's right. But the problem with saying that non-constitutional claims need not be raised, but the non-constitutional constitutional line is, here's what's going to happen. Every undocumented alien who's placed in expedited removal proceedings is going to wait and say nothing during the administrative process, and then only once they're ordered removed, say, hey, wait a minute, I have a constitutional challenge, and then they're going to be able to go right to the Circuit Court of Appeal. It's almost like a filtering effect. All legal challenges need to be raised because there are some that the Department of Homeland Security and an IJ and the BIA can deal with. And if this court draws a line between constitutional and non-constitutional, then the floodgates are open. Everyone's going to say, I have a substantive constitutional claim, and I need to appear before an Article III court. Now, I will just also note, an IJ can deal with a procedural constitutional claim. Not substantive, but procedural. So, for example, if an undocumented alien who's placed in expedited removal proceedings, say they never received their notice of intent, well, that's a notice issue. That's a procedural, due process, constitutional issue. Well, that's something that DHS can remedy. DHS can.
It's also a statutory violation, though, so it's not. I mean, before you get to any constitutional due process issue, they're really dealing with the procedural issue. I don't know, and you could tell me what you think, whether the IJ could deal with the adequacy of the notice of intent.
My understanding is yes, and the Board of Immigration Appeals has exercised jurisdiction over procedural.
So they could look at the notice of intent and say, this doesn't give appropriate notice for due process purposes. This form, sorry, DHS, go find another form.
I think so, yes. And one other thing, this concept of meaningful relief and the agency in front of which you're appearing not being able to afford substantive relief. This court, of course, hasn't ruled in the immigration context, and that's why we're here. But this court has looked at a similar exhaustion requirement in the Prison Litigation Reform Act, and that was Booth versus Turner in 2001. There, a Pennsylvania state prisoner desired two things. He wanted injunctive relief. He'd been abused and mistreated and all sorts of terrible things. He wanted to be transferred to another cell, but he also desired monetary damages. And at the time, the Pennsylvania Department of Corrections did not provide an avenue for monetary damages, only injunctive relief. This court said it doesn't matter. It does not matter. So long as the administrative agency in front of which you're appearing can grant you some relief, you still must raise it. And that's exactly what the Seventh Circuit said in Fonseca-Sanchez versus Gonzalez. Even if the agency can grant you some relief, all legal claims need to be raised. Otherwise, it's that floodgates problem that I mentioned earlier. Every single undocumented alien placed in expedited removal proceedings will just sit on their hands and say nothing. They'll have no incentive to participate. And that's not what Congress intended when it enacted expedited removal as part of the 1996 immigration.
Well, I mean, I suppose that your concerns about these floodgates, this parade of horribles, would also be served by somewhat more clear notice that legal arguments could be raised at the point of this hearing, no?
Well, I don't know how much more clear the hearing could have been. I see I'm out of time. If I may briefly wrap up.
You may finish your answer.
So even if the form is insufficient, this case is different because we have the hearing. Have we covered all of your arguments? That satisfies the test, this court's test, under Woodford versus No. Thank you.
Thank you. Counselor? You may proceed.
Yes, thank you, Chief Justice, and may it please the court. My name is John Lex Kennerly, and I also represent the United States Attorney General. This court should affirm the 14th Circuit's holding on the merits for two reasons. The first reason, looking to the text of the First Amendment, the petitioner is not one of the people protected by this amendment. The second reason, looking to Congress's power to preserve American self-government, the petitioner does not have a constitutional right to influence the process by which Americans govern themselves.
Are we really talking about influencing the the process, or are we talking about pure political speech here? And if it's pure political speech, why doesn't it deserve the highest level of protection, and why are aliens not allowed to engage in any political speech?
Yes, Your Honor. So there's not a single case where this court has held that someone who is in the United States unlawfully is protected by the First Amendment, nor that violations of rights that they do have automatically get strict scrutiny. This is political speech, and that is why it implicates American self-governance. And that is why Congress has the power having the power to preserve American self-governance and passing the Alien Sedition Act in furtherance of that power. That power overrides any First Amendment right that the petitioner might have.
Let me ask you this. Counsel talks about the concept of the people in the First Amendment, including those that have developed sufficient connection with the community. Now, the rare record here shows that Mr. Al has pretty close ties with his community and contributes greatly to it. What more would be required for him to meet your standard?
A legal connection to the United States. There is not a single case in which this court has held that someone who is here unlawfully is protected by the First Amendment. The high mark of non-citizens having First Amendment rights is Bridges versus Wixon. In that case, it was a lawful permanent resident. Justice Murphy actually wrote separately to clarify that, yes, by lawfully entering this country, you are in fact protected by the First Amendment. While the petitioner did enter the United States lawfully over 10 years ago, he has overstayed his tourist visa and for 10 years has been affirmatively disregarding the laws of the United States that govern the process by which you can enter the country.
So is it your position that if you are in the country illegally, no matter how long, no matter what age you entered, no matter how many routes you've established, no matter how much you've contributed, you have no First Amendment rights?
Yes. Now, yes. Now, this goes back to this court's opinion in Turner versus Williams, where this court said that one does not become one of the people protected by the First Amendment by an attempt to enter this country forbidden by law. And the court said that Mr. Turner, having entered unlawfully, is not protected. The petitioner talked about several cases from the Ninth Circuit and the Seventh Circuit that talk about sufficient connections. Applying this court's precedent, we see that term, the people, as used in the Bill of Rights, is a term of art. That's what we get from Verdugo. And in Heller, this court said that term, the people, especially as used in affirmative individual rights like the First Amendment and the Second Amendment, unambiguously refers to all members of the political community.
So all of the case law, all of the authority that discuss sufficient connections from your perspective is irrelevant. The only aspect, the only thing that we need to determine is, A, is he here? B, is he here legally? And if not, that ends our analysis.
Yes, for the terms of falling in that threshold question, are you protected by the First Amendment? You have to be here legally. The same is true for the Second Amendment.
So there are more amendments than the first that deal with the protecting the people. It also appears in the Second, the Fourth, the Ninth, and the 10th. Do you believe that the people means the same in each one of those amendments?
So, no, and the reason why is because the Fourth Amendment, being a protective right, as distinguished from the First and Second Amendments, which are affirmative individual rights, because the Fourth Amendment operates in an entirely different way now than it did at the time that the Bill of Rights was ratified, courts have expanded the scope of that amendment, and it's appropriate for the judiciary to have done so. That's why there are many cases where the lower courts, in applying Verdugo, have held that even undocumented immigrants who are here inside the United States illegally are protected by the Fourth Amendment. And that makes sense because the Fourth Amendment is telling the government not to do something. Don't unreasonably search and seize someone. It actually defeats the purpose of the Fourth Amendment when the government starts thinking that it's okay to unreasonably search.
Can't we view this as the First Amendment telling the government you can't arrest someone just because they're speaking?
Well, yes, we can, and in that regard, the First Amendment is protective, but it's protecting an affirmative individual right. And if I can illustrate this, the First Amendment gives you the right to go and do something. You can walk outside of this building and you can speak, you can pass out pamphlets. The First Amendment protects your right to do that. So does the Second Amendment. You can go outside and you can keep and bear a firearm. But you can't walk outside and on your own not be unreasonably searched and seized. That's not something that a person does. The Fourth Amendment is telling the government not to do that action to a person. The 14th Circuit made this distinction between the First and Second and the Fourth Amendment. That distinction is supported by the Fifth Circuit, United States versus Portillo-Munoz, where it made the same distinction between the Second Amendment and the Fourth Amendment. And we're asking this court to make the same amendment, to make the same distinction.
But isn't there a difference between the affirmative act of buying a gun, using a gun, and the affirmative act of speaking, which is part of normal life? Are you suggesting that undocumented aliens should walk around this country never opening their mouths?
No, Your Honor, not at all. And I submit to this court that if the law said it shall be against the law for an undocumented immigrant to speak words with their mouth, I think there are, Fifth Amendment and 14th Amendment and possibly 8th Amendment implications to something that egregious. That's not what we're dealing with here. Comparing the difference between free speech and keeping and bearing firearms, yes, there is a difference in how that plays out. That's relevant in the scrutiny analysis. That's not relevant to the threshold textual question that we have here, who falls within that term, the people. It's the same term in the First Amendment and in the Second Amendment. That's the same group of people, and there's an entire expansive regulatory scheme that makes it a felony for an undocumented immigrant to possess or to transport a firearm. Every circuit court that's ever considered the constitutionality of that statute has found that that statute is constitutional in terms of how the people...
But that's precisely my point. Yeah. We have clarity of the courts in dealing with the Second Amendment. We don't have that same degree of clarity with respect to speaking.
We respectfully, Honor, we do with Turner versus Williams and with Bridges versus Wixon, and even with Johnson versus Eisentrager. Johnson versus Eisentrager is the famous case that says that aliens are afforded with a generous and ascending scale of rights as they increase their identity with society. But the court says that that scale of rights begins with legal presence in the United States, having entered lawfully.
But I'm having a hard time because you're talking about this scale, but you're saying like the prerequisite for even entering on this scale is legal status in the United States, which if taken to its logical conclusion then, for example, there's a lot of immigration rights advocacy out there going on right now, right? So you're saying that only aliens who are legally within the United States and citizens can engage in immigration advocacy. And so we're depending on citizens and aliens with status to advocate rights of the undocumented and the persons who are here without legal status.
Right. Yes, I understand, and that actually brings me to the second point, which is even if you disagree with me and you think that the petitioner could fall within the people protected by the First Amendment, Congress's power to preserve American self-government, a valid exercise of that power overrides any First Amendment right that the petitioner might have. Now, to answer your question, Justice Wang, by lawfully entering the United States, which is what the Canadian attorneys did in the Blumen case. They were here on valid, they had permission to come here to work. They tried to engage in political expression relating to a political campaign, and this court summarily affirmed the decision there, saying that in the name of preserving American self-governance, they don't have a constitutional right to do that. Now, that is core political speech. What the Canadian attorneys were trying to do was what this court said in Buckley versus Vallejo. That was a political expenditure, which is political expression, which is at the very heart of the First Amendment. But because the speech implicated the way in which Americans govern themselves, there is a compelling government interest in allowing the political branches to be able to draw the boundaries on who it is that gets to engage in that political process.
So let's say that you're right about all of that, and we have the ability to keep aliens on the outside of the public square. But doesn't Congress have the obligation to pass a law that gives appropriate notice as to what is and is not allowed? So, for example, the phrase to participate in any public demonstration. Would you agree with me that if Mr. Al and I were in his apartment, just the two of us, and he made this very speech to me, that would not be a violation of the statute?
Yes, I agree.
And would you agree with me that if we were in his apartment and the six of us were there, and he made this very speech, that would not be a violation of the statute?
I do.
And would you agree with me that if the six of us, Mr. L and the five of us, were in a restaurant and he made the same speech, that would not be a violation of the statute?
I do, Your Honor. And Your Honor, I would like to say that these questions would be troubling if this was a facial challenge to the Alien Sedition Act. But it is not. And I can direct your attention to page 29 of the record, which shows the question presented.
Doesn't this appeal implicate the facial sufficiency of the statute?
No, it was relevant in the first issue in talking about who has authority to declare statutes facially invalid. Petitioner has challenged the Alien Sedition Act as enforced against him, and that's page 29 of the record shows the question presented. Does enforcing the Alien Sedition Act against the petitioner, who was speaking at a very large rally in the public square, and not just speaking, but doing exactly what the statute says that you can't do, which is advocacy, advocating for a change to a law of the United States. That is what the petitioner was doing, and that falls within the pretty clearly defined conduct that is outlawed by this statute. This statute was passed in furtherance of a compelling government interest. In Blumen said a compelling government interest in preserving American self-governance. This court has also recognized compelling government interests in preventing interference in elections, think polling location regulations and that type of thing. This statute is narrowly tailored, but I want to be clear, there's only one case where this court has talked about the precise distinction being made here, and those are distinctions between undocumented immigrants and people who are here legally but who are non-citizens. Undocumented immigrants, lawful permanent residents, lawful temporary people, that is Plyler versus Doe. And in Plyler, this court held that rational basis is the form of scrutiny that applies to those types of distinctions. Rational basis requires that there just be any conceivable legitimate government interest. We submit to this court a compelling government interest, and the means are rationally related to that end. I don't know if you had a question.
No.
I was going to say, finally, we, at the heart of our argument here is and I realize that we're talking about some things that are very important to a lot of people, especially in today's environment. At the core of our argument is the same thing that's at the core of one of the founding values of this country, and that's that we are, in fact, a nation of immigrants, but we are also a nation of laws. And by failing to enforce our laws, that does not help us further the tradition of being a nation of immigrants, but actually harms our ability to do so because it dilutes the political process that allows us to maintain the system that we have that gives.
Well, I mean, you may or may not agree with me, but the name of the statute, the wording of the statute, for those of us steeped in civics from the third grade on, is jarring, right? And part of what we learn to appreciate is that there be robust debate. And when it comes to immigration, which is a very important issue and has been for decades in this country and increasingly so, why are we shutting down the voice of the very people that the debate is about?
We are not, Your Honor. We are preserving the debate by deferring to the political branches. And I'm sorry, I saw that I was out of time. If I could answer your question. This court in Trump versus Hawaii said that we defer to Congress when it's validly exercising its power over immigration and naturalization, foreign affairs, national security, preserving American self-government. This statute is in furtherance of that. Therefore, we do not need to consider the First Amendment claim, just like how there was a First Amendment claim in that case regarding the travel ban, as this court seemed to do that begrudgingly in that case. But if Congress is exercising within the discretion that the Constitution affords to it, it's not appropriate for the judiciary to second-guess the political determinations that they make. Thank you.
Thank you. Any rebuttal?
Yes, Your Honor, 2 minutes. May it please the court, Your Honor's 3 points on rebuttal. First, Mr. L isn't a lawyer. That form did not tell him to raise a legal claim. And the circuit split regarding issue 1 makes it clear that attorneys and judges alike are confused by how that form is to operate. Next, Your Honors, there is a significant difference here between protective and affirmative rights. Again, there is not one opinion published by this court that has called the First Amendment an affirmative right. And that's because it's well established that the First Amendment is a shield and not a sword. However, this court in Kwang Hai Chu v. Colding did hold that when it comes to the First Amendment, it does not distinguish between citizens and residents, alien residents, because that is an inalienable privilege that seeks to guard all from encroachment by the federal and state governments. And finally, Your Honors, the compelling government interest cited by the government today is invented post hoc in anticipation and response to litigation, which this court in United States v. Virginia excluded the government from doing. The Congress in this case never said that the concern that they had was foreign interference in our elections. So this is not like Citizens United. However, we can look to Citizens United for guidance here, where this court said that Congress cannot silence the voice of some to heighten the voice of others. And for these reasons, we ask this court to reverse the 14th Circuit's decision to deport Mr. L. Thank you.
Thank you. Okay. Any further rebuttal? Okay. All right. Thank you all, counsel. You've given us a lot to consider, and we're going to retire to our deliberation room and hopefully have an answer for you shortly. Thank you. Okay, you may all be seated. Many of you know that Justice Cardozo said, "Justice delayed is justice denied." And for that reason, my fellow judges and I tried to deliver justice swiftly and make a swift decision, but by no means was it an easy decision. I want to commend all of the attorneys here who participated in this remarkable oral argument. We were challenged by what you had to say. You know, some of the arguments we thought we were going to know. Some of them we were surprised by. It's a good thing. It's a good thing. You kept it fresh. We thank you for educating us about something that is so important. And I think perhaps some of my fellow judges might have a statement or two as well.
Sure. So first of all, let me congratulate all of you. One of the things that I appreciate a great deal when I have lawyers before me, and I don't sit on an appellate panel. It's just me and my clerks, and so I depend a great deal on the lawyers to be straightforward with the court, to present the facts in an unvarnished way. I anticipate advocacy, of course, but I also anticipate honesty. And I think all of you did that. You did that respectfully. You knew the record. You portrayed it well. You conceded when you had to. And were able to make arguments from those concessions. So congratulations on a job well done.
I would like to just add that to me, it was close to a four-way tie as far as the oral list. I get that the respondents had a harder argument to make, but what I really liked seeing was how you responded to each other. So it wasn't just that you had your argument and then you were responding to the judges, but I believe I saw respondents specifically attacking something that the petitioners had said, and then obviously on rebuttal, it was very narrowly tailored to the respondent's argument. But then also, I think, Joseph, I think you took one of my questions that I had asked the petitioners and turned it back on me when I asked the flip question on you, which I thought was great. I mean, you were really listening and you were taking, you were gathering ammunition even as you were listening to the other side argue.
I'm not a sitting judge, so I really respect the fact that you got hit hard with a lot of different questions and reacted with nothing but polite seriousness back, which is not an easy task to do, especially when you really believe in what you're trying to get across. So my hat's off to all of you for dealing with a difficult bench in a very professional manner.
You're waiting to know what the result is, but I will humor you just this little bit. I talked to you a little earlier about the American College of Trial Lawyers. It's an invitation-only organization. You have to have practiced for 15 years and be known as a great trial lawyer of unimpeachable ethics and collegiality, because the organization stands for professionalism, ethics, independence of our judiciary, and collegiality. And all of you exhibited all of those things today. And I was very impressed by the way you counter one another's arguments, the way you treated one another in the well of the courtroom. And I'm sure that in about 15 years or so, we'll be encountering you as fellows of the college as well. Congratulations.
Okay, before we announce the winner of the round, we want to just give a big round of applause both to our competitors and also to our judges for judging here tonight. As you can see here, we have a series of awards we'd like to give. The first would relate to the briefs. So this year, the Harris Tweed Award for the best brief goes to Creighton University. I'm not sure we can give an applause anyway. The award for the runner-up best brief goes to South Texas College of Law. We now have awards for the individual speakers in this round. The award for the best individual speaker goes to Joseph Sturenberg from University of Georgia. And the award presented to the runner-up individual speaker goes to Mesa Daoud of St. Louis University. May I ask the president of the American College to step down and to help us introduce the next award.
It's a good thing this wasn't happening during the argument.
Yeah.
Yeah.
So this is the John W. Davis Award, which is awarded to the best team in the program tonight. Will be announced by someone else shortly, but I want to tell you a little bit about John W. Davis. He was a politician, a diplomat, an outstanding lawyer. He was in the House of Representatives from West Virginia. He was the Solicitor General of the United States. He was our ambassador to the United Kingdom. And he was also, as it turns out, president of the New York City Bar Association. So it all comes home again when you bring it around. As I said, he lost the first 3 cases he ever tried. And in fact, when he got out of law school, he couldn't even get a job. But he persevered, practiced law for 60 years, argued, get this, 140 cases in front of the United States. He lost quite a few, but he was one heck of an advocate and really stood for the proposition that the rule of law for advocacy and for professionalism is something we all should strive for no matter what. So I'm going to present this to...
Madam Chief Justice, it's the verdict of the court.
It is with great pleasure that I announce the winner of the round as being the respondents, and there's been no reversal on the brief. So congratulations.
So I think it's University of Georgia, and I think you're allowed to lift this thing up if you can.
And we're also pleased to announce the runner-up Best Overall Team awarded to St. Louis University. Okay, thanks very much. The judge will be down for a quick photo. Thank you very much for attending, and this concludes the 70th National Moot Court Competition. Thanks very much.